It is absolutely fabulous to see everyone in person since it's been a while. So welcome, welcome, welcome. And you all look lovely or handsome or whichever derivation you want, even with the masks. So I'm mic'd up and I'm generally like super loud and obnoxious either way. But if for some reason you can't hear me, let me know and I will yell a little bit louder. So my name is Julie Proscia. I have the pleasure and privilege of being one of the partners at SmithAmundsen in the Labor and Employment Group. I see a lot of faces of individuals that I work with. I am mostly hubbed in the St. Charles office, though really my car is my predominant method of where I am, or at least it used to be pre-pandemic, and now it's kind of my home office with my dog on my feet, which is baller. So the only good thing about the pandemic is a pandemic puppy. So there you go. So what we're going to be doing, we are ending it off with non-COVID talk, which is kind of exciting. I have a couple clients, particularly a couple clients that are in the room today, who will call me up and be like, listen, this isn't a COVID question. Hang on, we're exciting. We just have a regular drug pop test. And we're like, woohoo, something else. So that is what we decided to end off on so that everybody else gets a little bit of a variety for what we're doing. And so what we're gonna be talking about are things to come. And essentially it is stuff that missed on your radar because you guys were too busy trying to figure out how to get your businesses open, how to get your employees remote, how to have them wear masks, who to fight with when they weren't wearing masks, and so on and so forth. So these are a couple of the things that came down the pike. So the first one we're going to talk about for a little bit is the changes to the Illinois Business Corporation Act and the Illinois Equal Pay Act. So I'm going to premise this with, it's going to sound really scary for the first 4 slides. So hold on, don't freak out. It's not quite as scary as it sounds, which actually just kind of gave you guys the impetus to not pay attention for the next 6 slides because I just said that, you know, it's not as scary as it sounds. So what happened is this year in March, the legislature passed amendments to the Equal Pay Act and amendments to the Business Corporation Act. And essentially what it says is that businesses with more than 100 employees, and very similar to what it is if you file an EEO1 report, you are falling under this category essentially, have to, in order to be in compliance, file reports with the state regarding, which are going to be similar to the EEO1 report because they haven't actually put out what the annual report is going to be, regarding employment data that's similar to EEO1. What they're looking to see is, are we paying men and women equally? Are we engaging in Equal Pay Act compliance? And we're going to have to register a certificate with the state. And the reason I'm saying that this is like a little bit scary because it is a lot of data that you have to put together and that you're required to put together is that it doesn't begin until January 1 of 2023. Now that doesn't mean that everybody needs to forget about it until January 1 of 2023 because otherwise in December of 22 you are going to be trying to do a very janky benchmark study to figure out if males and females are paid in a similar fashion. So we need to kind of know about this ahead of time so that we could start figuring out how we're doing our process and what we're doing for salary surveys and benchmarking. But it's not something that is fire, fire, snake, snake, run that you have to do right now. Okay, so a little bit of a backup is fire, fire, snake, snake, run is you run if there's a fire, fire, and if you're hiking and there's a snake, you run for that too. And that is the emojis that my husband and I send to each other. And I'm like, if somebody breaks into the house, don't just send me emoji, yell. So fire, fire, snake, snake, run, it is not. This is just like one fire, one snake, no run. So for the annual business filing, so like I said, so it's reporting. It's a certification, it's an annual business filing. For the annual business filing, it's essentially corporations that are gonna have to do it that are over 100, right? So we kind of talked about that. It's for the individuals who are similar to the EEO1 report. And we're gonna have to submit data to the Secretary of State, and here's the thing, they're going to publish this data. Theoretically, they're going to be publishing it 90 days after it's sent to them. Now I say theoretically because universities have had to do things like this, and I have a couple university clients for a number of years now, and that stuff is not published still, and that's been years. So theoretically it's gonna come up 90 days afterwards after you file the report. And this is gonna be required for businesses that begin, again, on or after January of 23 that's going to happen. You're also going to have to register with the state. And the registration with the state is, again, businesses with over 100 employees. This is over 100 employees, though, in Illinois. So that's a little bit different for the registration aspect, for the registration certificate. So if you have 100 employees in bits and pieces, like where it's just a total of 100 employees, Colorado on out, that's not the same thing. So it's 100 employees in Illinois. This application, the certificate requirement that we're going to have to do for registration, is essentially that we have to first obtain the registration and certificate. We have to apply, right? We have to do the annual certificate. And we're going to be subject to the requirements that in 3 years, that we have to get the certificate within 3 years of the effective date of the amendment. Amendment was effective March 1st, so in 3 years, 24, right? And then every 2 years after that. So the certificate process, and this is the part where I was talking about where it's not a fire, snake run, it's just a fire and a snake, and you don't need to run, because we are gonna have to gather together some information for when we're doing our registration. So we're certifying that, yes, we are not just submitting the information of the data of male and females, what our compensation is, that individuals, but we are also certifying that we are doing this. We're doing comp studies, that we are ascertaining whether or not individuals are paid in a comparable manner. So we're gonna have to certify that the average compensation for females and minority employees is not consistently below the average of male and non-minority employees. And so how do you get that? You have to do some type of salary survey. You have to do some type of benchmarking. The state, and I'll talk about this in 1 second, but the state later on came back a few months later and we're like, oh, well, maybe we'll do a couple amendments on that, because at first it was like, and we're gonna create the how you have to do the benchmarking. And then they were like, oh, we're kind of busy with other things. So how about you guys just do a good salary study and you guys figure it out how you're gonna do it, type of thing. And you just tell us you did it and that you did some type of comparable study. We have to certify that we're not restricting employees of one sex to certain job positions. That, male only, you can't apply for this position if you're male or female. That the wage and benefit disparities are corrected when we identify them. So not just we did the salary comp study, we did the salary analysis, but then we did something with it, which is like always kind of the hard one, is the next step. And we kind of laugh about that, or I used to laugh about that. I'm like, do not put out the suggestion box. Do not put out at the end of the survey, tell us all the problems that you have with us in HR, unless you are going to do something about it, because then you have made, you have made everybody else super mad, because you're like, why did you ask the question if you didn't do anything about it? So this is like the next part that's almost worse than the first part, because now that you know, you're like, oh, so hey, everybody, we need to come up with $1 million to rectify all of the disparities that are happening, because there are going to be disparities, because not even because of sexism or racism, though that does exist, but also because we tend to hire people in. Females tend to historically be really, really bad at job interviews asking for money. And if they made bad money in the first job, and then before they change it where you could say how much you made, and the next job you're like, hey, I made $32,000, an employer, because we are businesses for profit, and even nonprofits are still businesses that need to, keep the lights on, are not gonna be like, well, or at least back in the day, weren't gonna be like, well, the job is benchmarked for 87, but you'll take 32. No, we're gonna pay you 87. Most people don't. So there's gonna be disparities that are listed that we're gonna have to correct. And again, employers that are required to file the EEO1 report must also include a copy of their most recent EEO1 report. That's like the easy part. I already have it. I just have to attach it and forward it. So just a quick reminder, if you're like, do I have to file an EEO1 report? Because I've been kind of focused on other things for the past year, and I don't really remember anything other than, what I'm supposed to do about things related to COVID. This is the quick and gentle reminder of whether or not you have to file an EEO1 report. So it's essentially it's the threshold for 100 or more employees unless you're a federal contractor. And then that threshold gets a little bit lower, right? So then it becomes like if you're 50 or more employees, if you're also a prime contractor, a first-tier contractor, you have a contract or subcontract that's over 50K, you serve as a depository of government funds, hopefully you are a bank or some type of credit institution and not just in your basement for that one. This is what the E01 report looks like. Again, this is just the gentle reminder for all of us who have been in a fog. We don't have, or at least I don't think we have, I didn't check this week, but as my most recent checking, we didn't have the form of what the registration is going to be for the Business Corporation Equal Pay Act amendment, but it is going to be similar to this, is what they're saying. So I kind of alluded to this beforehand. So they passed it in March, and then all of the business interest groups were like, whoa, like we're kind of busy with other stuff. So like if you could not throw something else on us, we would really kind of appreciate it. And while you're doing that, if you can make it so it's not as stringent on us, we would also kind of appreciate that. So in June of 21, so just a few months later, amendments were processed. And so the amendments made it so that employers that are subject to the certification requirement as of March 23rd of 21, right? So you had 100 or more employees, you were doing business in the state of Illinois. In March of 21, they have to apply to obtain the Equal Pay Act registration certificate, the thing that I was talking about, between March 24th, 22, and 24. So it's like very clear cut. Okay, so if I was doing business at that time, I need to do my application at that point in time. If I'm a covered employer that needs to obtain, if I'm going to start doing business after March 23rd of 21, I open my business after that, I have to apply within 3 years that I start my operations. So it's kind of like, in my mind, a little bit of the grace period of like, you can figure out how to open your business and get clients and customers, and then you have to do the application. And then the recertification occurs every 2 years. Yeah. Yes. So I didn't mean yes, but I was like, yes, you got it. Because I had to read it 3 times because it's written in Greek. So the question was, because it's it just seems super easy, 100 employees. So Susan was 100 employees by establishment, because it's just like the EEO1, except it's not. So it's clear as mud. So it's not by establishment for Illinois. For this, it's 100 employees in Illinois, not necessarily by establishment. But the reason that I say it's like the EEO1 is because if you have to do the EEO1 in Illinois, you're going to have to do this. You're going to fall under it. I can't see the exception where you wouldn't. Yeah, no. I said you could sit in front if you didn't heckle. That is a very good question. It's going to be 100 employees preceding the application time. $90 days before the application time. The year before. So he's my worst client, and I told him not to sit in front. And now he's a former client. Okay, so I got one more joke in me, and then, okay, certification requirements. Okay, wait, that was just bad. I can't stand and see there. I'm used to walking but not holding a mic, so bear with me. Certification application requirements. So when you're looking at covered employees, what do you have to certify? So what are the requirements? So you have to submit the wage records list, right? So it's all employees. So this is where I said it starts getting onerous of what are you submitting? All employees in the past calendar year, so that's the calendar year you're looking at for the wages for what you're looking at, categorized by the county in which they're employed, because there's a big difference in salary if you're going LaSalle County versus Cook County versus Coles County versus Lake County, right? And then the breakdown of it, gender, ethnicity, race, the corresponding period. And so what they're looking for is like to like, right? So are the individuals in essentially Cook County or Northern Illinois paid similar to each other? Are the individuals in Southern Illinois essentially paid similar to each other, to see if there's any pay disparity that exists? And then if you're under 100 employees, then you just have to certify, I'm under 100 employees, sucker, I do not need to do this. Might want to leave out the sucker part of it. So like I said before, in the beginning, it was like, okay, so we're going to give you a compensation system that you need to utilize to ascertain how you're going to be able to do this. And then later on, the amendments walked it back, and they're like, how about you just use an approach in which it's an acceptable approach that you're going to look at compensation that includes but is not limited to wage and salary surveys. So pretty much figure it out. So really what it is you are going to find your very friendly HR professional who does benchmarking studies and comp studies and take a look at that and take a look at the different studies to ascertain, like, what is the average in this field? What are my competitors paying? You know, so that you're kind of getting an idea for what individuals are. And, you know, it's new, bless you. So we don't know exactly how nitty gritty the DOL is going to get on the breakdown of, you know, if customer service rep is an average of $54,000 a year, like how nitty gritty they're going to go down to see if it's 7 years versus 15 years versus 20 years. But if you're doing a true benchmarking comp study, it's also commiserate to years in experience as well. And I think somebody raised their hand back there, but I ignored you. Okay, so you're banned from asking questions too. So the question was, no, I don't even want to repeat the question, but the question was, is it in the county, when you have to do it by county, is it the county where they live or the county where they're reporting to? It's a really good question, and I actually don't know the answer to that because it doesn't break it down in the statute, and in my recollection, it's not defined. My guess would be that it would be the county of which is the office that they're headquartered out of, particularly if they are not permanently remote work and that they are considered a temp remote work but will eventually go back to the office. If it is something where it is a permanent remote work, where that is now their official home office, then I think it would revert to the county in which they live. So that is my educated guesstimate on that one. But I don't have the for sure yet on that one. Mm-hmm. I'm giving you, kind of teasing you, because I think playing Stump the Lawyer is super fun, though that was not a challenge. That was not a challenge. So there's penalties, because there's always penalties, right? If you don't do this, what happens to you? And the amendments really dialed back the penalties, and this was actually one of the big things that a lot of the Illinois Chamber of Commerce and the other trade associations were protesting, because when it first came out, it was that it was going to be 1% of your annual gross profits. And everybody was like, whoa, okay, ooh, like this, it's getting like a little harsh, particularly since we're not really making any profits right now. And like, that's getting a little bit harsh. And it switched to a penalty of $10,000 for a violation of the Equal Pay Certificate, which is kind of a big difference. Depending upon how much you do. There's also a grace period. So you get a 30-day grace period to correct an inadvertent failure if you timely didn't file an application. And I gotta tell you, you would think that you couldn't put it together in 30 days if you need to, but I have seen Heather Bailey put together an affirmative action plan in like 2 days with no sleep and 42 shots of coffee when push comes to shove. It's not a challenge for her to do that for you guys, but like, we could do if we absolutely need to. We do not want to do that. But third-party access, that's actually one of the, I feel like this is a trend in labor and employment laws, or just in laws in general, where it's, hey, so not only can our employees sue us, but like, who else can get access to information and who else can sue us? So there's third-party access. So that means that current employees of covered entities can request anonymized data regarding their specific job classification. So take out the people and let me know how much other individuals are making, their pay scale. And so that's good in that it's a little bit of sunshine. It's also bad because depending upon how large you are, Illinois' data isn't going to be anonymized in an organization. And the June amendments also put forth that IDOL employees can't leak information. So this is the, hospital, Britney Spears, R. Kelly rules that you can't leak the private information out to the public. So the first half of kind of what we were talking about that came through in March when nobody was paying attention to it because we had, other things to do, was the Equal Pay Act Business Corporation. Another thing that came through this year, which really impacts a lot of businesses, particularly right now where employers are struggling to get employees, to keep employees, to find ways to successfully open and keep their businesses open because of the labor shortage, was revisions to the amendments to the Illinois Freedom to Work Act. So it's non-competes, non-solicitation clauses. Illinois is, shall we say, not a friendly state for non-compete. You could just say it's not a friendly state, but it's not a friendly state for non-compete acts. And every year it gets more and more restrictive of how we can restrict individuals for employment. Courts are very abhorrent to any type of restrictions for any type of competition or solicitation. And this is just kind of a continuation of this trend. So what it really did was it put forth salary caps so that individuals who, and this is starting on January 1st of 2022, meaning if we need to get them in place, we need to get them in place before January 1st of 22, okay? So starting on January 1st, you can't do a non-compete act. You can't do, or an act. You can't do, Mike's like, oh, geez, it's been a while there. You can't do non-compete provisions. You can't do a non-compete agreement with individuals if their salary is less than $75,000 per year. And that's their true salary is how I would say it. So it is their salary that includes all of the known things that they are getting. So if they're getting if they get a quarterly bonus of $25,000 a quarter, if they have a base of X amount, it's their average salary. So it's not like, they get a discretionary bonus at Christmas that could be $5,000 or it could be $500,000. So we're going to say that it's going to be $500,000, and then that's why we're going to put it up to that. Would have winked at you, but you were trying to stone me earlier. So yeah, so that's what it gets to for January 1, 75. So that really takes out a lot of individuals, and then there's clauses that kicker it every year. So in that might be 32. It's 85. 37. Is that right? I think that is. Huh? Thank you. I was like, okay, this is what happens when you're reading backwards and upside down type of thing. Thank you. So there's kickers of what it goes to up every single year. And then that is only for non-compete agreements, right? So for the non-compete provisions, you can't go work at my competitor. There are also things for non-solicitation provisions, and those are different. So non-compete is you can't go work at this competitor. Non-solicit is you can't solicit our clients. You can't solicit our employees. You could go wherever you want, but you can't take your accounts and our customers with you. And so for that one, it's, as of January 1 of 2022, it's $45,000 per year. And that means that if they make less than $45,000 a year, and it's the same thing, it's the monies, the salary, the earned bonuses and compensation that you would assume or average that they would be making for $45,000 per year and 27, and then it goes up to $50,000 and so on. So additional prohibitions. And so this is the COVID component of it, which is essentially that if you fired somebody or laid them off because your business was closed, your business was slow, we didn't have a lot of work because of COVID, you can't then ding them for it and then put the non-compete provisions in play. You can't then say, well, we didn't have enough business for you, so we had to lay you off, but you can't work anywhere else either. So that's kind of the leveling the playing field with that. And I think that is one of those provisions that's for the outliers. Like 99% of employers wouldn't do that. But that's actually how all laws are made, right? 99% of everybody's super good, and you have to make a law for 1% of the individuals. So, yeah. Pre-signing and notice period. So we now have a little bit different of a pre-signing and notice period, where if we're going to do a non-compete or non-solicitation provision, they don't count for anything. And again, this is after January 1, or this was effective on January 1, unless we advise them in writing that they can consult with an attorney. So similar to like when we're doing a severance agreement, that they have to, we have to advise them in writing that they can consult with an attorney before they sign it. And that we give them a copy of the covenant at least 14 days before they start, or 14 days before they have to sign it. So it's not one of these, hey, so we're offering you a job and you need to sign this, read really quick and hand it back to us. They get 14 days to do it, which is kind of a long time for them to be able to do it. And there's also almost all non-compete agreements that you'll see or that you've seen in the past. What we would say is that if we have to go after you, then you have to pay our attorney's fees. And this is saying you could absolutely do that, but you have to do it both ways. So if you lose, then you have to pay for their fees and costs as well. So it is, it is a fee apportionment for whoever prevails within the litigation, which is going to give, I think, employers a little bit of pause sometimes, because non-compete litigation, I would say, is, what do you think? Probably the most expensive litigation right away for employers, because it's a lot of money really, really quick. Because that is a fire, fire, snake, snake run thing. Somebody leaves your business and they take a bunch of your confidential information and they take a bunch of your clients. It doesn't matter if you do it 2 years later, because they've already taken your clients and they've already taken your business. So this is we need to do this in an emergency right now. So that is a lot of ramp up really quick. So it'll give, I think that section will give employers a little bit of pause, because generally we don't have all of the information yet. We know they left. We know that they took a thumb drive and downloaded all of the stuff. We know they're at a competitor. A lot of times employers will kind of block it, because we're like, we think you're doing this, so we need to stop it, but we don't have quite all of the information yet. This is kind of a pause of like, but if we're wrong, then we might be out about $50, $60, $70, $100,000 type of thing. And the AG's office can enforce it when they're not doing other things. So, okay, just a couple being three, other miscellaneous actions that came in that are upcoming for January 1 of 2022 that could kind of get on your radar but aren't like super, super pressing. Equal pay deferred compensation. It's just the aggregate amount for when you're looking at it for the equity. That one's not really as, I think, like is big or anything like that. The definition of disability expanded a little bit to mirror kind of what we're looking at when we're looking at other protected categories. So it's not just if you yourself are disabled or if the individual employee is disabled, but also if we are discriminating against them because of their association with the disabled person. Their spouse is disabled, their child is disabled, and therefore we're firing them because we're concerned that their child or spouse is going to jack up our premiums. And I am sorry, I do not know how long your hand was up. Just say it was up for a second.
Finish this slide, and then I have to go back to non-compete.
Done. Well, that was easy. Expansion of VESA. So VESA expanded a little bit. So VESA is the Victims Economic Safety and Security Act that gives reasonable accommodations for individuals who are victims of domestic violence, that gives leave time for individuals who are victims of domestic violence or individuals within their family, gives people the opportunity to get to a safe place, to get the locks changed in their house, to do things like that. And it says we can't discriminate against them as well. So this expanded a little bit and has been expanding so that it's not just domestic violence, but it's things like sexual violence, so that it's expanded upon them and association with. Again, we're not going to fire you because your family member is a victim of domestic violence, your child or your spouse, and you could take care of it if it's your kid as well, not just you.
Okay, so with
Yes.
the non-competes, all of the amendments have been added in and they're done and it's all effective January 1st, right?
So good question.
Or
Okay.
are there still pending amendments to that?
Oh, back is the back. There we go. Okay, so the notice period, the who prevails in litigation and the enforcement, that was effective on January 1. So that is what it is type of thing.
Okay.
So that's already in effect. The salary markers of the 45,000 and the 75,000, seeing you guys didn't think I would remember that since I went with the wrong year. I gotcha. That one is effective January 1 of 22.
22. Okay.
Yeah.
Adequate consideration.
Oh, good question. The question, yeah, thank you. The question was like, what would be considered I'm extrapolating now. The question is, what would be considered adequate consideration when we're talking about non-competes? And the answer is, meh. So it really is going to, I know, it really is going to depend on each job and each position. So, for adequate consideration, I would say $100 is never going to be it. I would say if an individual, because of the kicker of the attorney in there, I think you might be able to get it a little bit lower. So, because now you could say, well, they had an opportunity to have an attorney look at it, or they had an attorney look at it, and I talk fast. Sorry, I'll hurry. Or they had an attorney look at it, and so we could give it a little bit lower. So I think that if they negotiate, let's say, an extra week of vacation, generally I would say that that's adequate consideration. If it is, if they're just so if it's before January 1 of 2022 and they're making $45,000 and we offer $1,000, probably adequate consideration. If they make $500,000 and we're giving them $1,000 and we're saying that they can't work anywhere else for a year, it's not gonna cut the mustard type of thing. So that's what I mean. It's you have to kind of look at it like all of labor and employment, with what is it in comparison to? But I think you might get away with a little bit lower if they had an attorney review, because you really can't argue that it wasn't adequate to consideration when they had the ability to consider it with somebody else. So, yeah.
Thank you.
You're welcome. So before I throw it over to Mike so that he could wow you with what is going on with unions and all of that good stuff, did I miss anybody because I didn't necessarily see your hands up? Okay. Well, thank you guys. I'm going to turn you over to Mike.
Can you hear me now? All right. Should I do like Julie and yell and talk into the microphone? All right.
I need a microphone, so yell back.
Yeah, we know. My office used to be close to hers. Now it's far away, and I still hear her the same. Okay. So, federal update. I think there's hot spots on this mic. I got to keep turning it to. Okay. Federal update. We're going to talk a little bit more than just about unions. So Julie gave you kind of an Illinois update, what's happening now in there was kind of a lull with COVID back in 2020. They weren't passing a lot of laws in the Illinois legislature. Well, they caught up they made up for lost time. I'm going to stand on this side, it's easier. And passed a lot of stuff, the non-compete laws, the Equal Pay Act stuff, a lot of stuff with economic issues tied to it and penalties and things like that. Well, the federal government, now that there is a new administration, I'm going the wrong way. There's a new administration is not losing any time either. A little harder to pass laws in the federal government based on the way the legislature is set up than it is in Illinois. In Illinois, it's pretty easy for the Democratic Party to get its agenda through because it controls not only the governor's office, but both houses of the legislature. So it can get its agenda through a lot easier, and then employer groups and chambers of commerce and things have to kind of pick away at things before it finally goes in, maybe get an amendment in before it goes down the pike. In the federal realm, it's a lot harder. It's a lot harder for one side to just push their agenda through, except when you're talking with agencies. And so the agencies, like the NLRB, the EEOC, the U.S. Department of Labor, the executive, the president, gets to appoint his people into those positions. So there's a changing of the guard whenever there's a change of administration, and we can expect, and we've already seen, that that's happening. And some of the policy provisions and some of the agenda items that those agencies want to push are coming to fruition because it's easier for them to make a change on the fly. President Biden, in his pre-election promise, says he wants to check the abuse of power by corporate executives and over labor, and hold corporate executives personally accountable for violations of labor laws. We'll see some of the provisions they're trying to put through for that. Encourage and incentivize unionization and collective bargaining. We're seeing a lot of that with the new makeup of the National Labor Relations Board, as well as the new general counsel of the National Labor Relations Board. And ensure that workers are treated with dignity and receive the pay, benefits, and workplace protections they deserve. So we expect to see a lot of ramp up of employee protections, EEOC changes, OSHA, and we'll talk about something from OSHA that came down today and something from the NLRB that even came down today. So a lot of stuff going on. Okay, so I got to back up because that's too small. I'm not going to go through all this. Here's a lot of the new people that have been appointed into positions. You've got Marty Walsh. She's the Secretary of Labor now. He is a former union president and president of the Construction Trades Council in Boston. Julie Sue, the U.S. Department of Labor's Deputy Secretary. She is heralded by progressive groups and employee advocacy groups as an ardent worker advocate, innovative wage enforcer. Jim Frederick is the acting administrator of the and Deputy Assistant Secretary for OSHA, formerly with the United Steelworkers from '94 to 2019. OSHA hasn't had a permanent Senate-confirmed Assistant Labor Secretary since the end of the Obama administration, and now they have one who is a lifelong union member. So something, I don't cover OSHA here. I know you guys talk probably a lot about OSHA and COVID and things like that. I just got an alert as I was coming in here today that they are expanding the fines for employers that are not following their OSHA guidelines for the COVID protocols. So your fines are maybe increasing fivefold if they find that you're not following their guidelines. We expect new guidelines to be issued soon with the vaccine mandate, and with those, you're going to have fines potentially instead of $13,000, $70,000, and if it's willful and wanton, instead of $130,000 or repeat offender, $700,000. So they are not playing around with the enforcement mechanism for some of the new mandates that are coming down. I won't bore you with the rest of these. Suffice to say, as the guard is changing at the EEOC, the White House assistant labor deputies and the EEOC, we're getting people that are either union or union adjacent or other employee advocacy groups that are pushing the regulatory agenda. And again, much easier to get through regulatory changes, policy changes, than it is to pass new laws. And the NLRB, a lot of people think this is just governs unions and employers who have unions. Not true. The National Labor Relations Act governs every employer and gives your employees rights to organize if they want to push a union if they want to engage in other protected concerted activities like petition you for increases, to go on strike even if they're not in a union. I have a situation where I have an employer with 2 employees that are out on strike now. They don't have a union. They got 2 guys out on strike. And you have to know what your obligations are in that. You can't fire them. You have to let them be on strike. And there's rules about if you can replace them or if you can permanently replace them when they're out. It depends if they're either economic or unfair labor practice strikers. But it applies to everybody. A lot of people think, no, I don't have a union. I don't have to worry about the National Labor Relations Act. I don't have to worry about the NLRB. They're making it more and more so that you do have to worry about it because in Inauguration Day, President Biden fired the NLRB General Counsel. And the General Counsel for the NLRB really sets their enforcement agenda. Here's the things we're going to be looking out for. Here's the type of cases I want to issue complaint on. Here's the type of maybe changes in our policy that we want to see. For example, today, Jennifer Abruzzo, who's the new appointed NLRB General Counsel, she's former Special Counsel for the Communication Workers of America, just issued a rule that student athletes at private colleges will now be considered employees of those universities. So people might remember, I think it was 2015, the Northwestern University football team tried to organize, they filed a petition, had an election. The NLRB at that point said, we're gonna impound the ballots because we gotta figure out if you guys are really employees or not. And they kind of punted on the issue and they said, you know what, it wouldn't promote labor stability, which is something we want. So we're not going to answer the question of employer-employee, but because it wouldn't promote labor stability, we're not going to allow the election. That was also under a Democratic majority NLRB, but they didn't have a general counsel who was already saying, yes, they are employees. So we can expect that another private university, or maybe even Northwestern, will have a petition pretty soon for their student athletes to be considered a bargaining unit, so they bargain with the university over terms and conditions of their employment. That's some of the types of stuff that they are actively trying to push. On what's important about the fact that President Biden fired Peter Robb, the former general counsel, on the day of his inauguration. It's never happened before. His term wasn't up until November. He was fired the day that President Biden took office. He was a lightning rod. The unions did not like him. He had his own agenda that was not aligned with theirs. He was pretty aggressive on certain things like, we don't want to allow the big inflatable rat to be out in places. We think that should be considered picketing and subject to the same rules as picketing. They didn't like that. They got him out day one. Day two, appointed Peter Sonora, who was our regional director here in Region 13 in Chicago, as the acting general counsel before appointing Jennifer Abruzzo. But in Peter Sonora's short stint, he immediately issued memoranda, general counsel memoranda, reversing many policies and provisions of the labor board. Reverse position on neutrality agreements. So previously, some neutrality agreements, which is an agreement between a union and a company that says, hey, if you organize our company, if you try to organize our company, the company will stay neutral. We won't put on a campaign against you. We won't educate our employees about what it would mean to be in a union. We'll stay hands off. You can get cards signed, and if you get a majority, we'll recognize you. Some of those agreements also included things like, okay, if you get in, we'll give you this, this, and this, or some framework of an agreement. That was considered unlawful because you can't give assistance and you can't bargain and negotiate with a union that is not, in fact, representing a majority of your employees. So until you know that, you're not allowed to bargain with the union other than in the construction industry and some other garment industry people. But reverse that and say, yeah, no, that's fine. We want people to do that. Reverse, and so that encourages corporate campaigns, unions to hit not just trying to organize the employees, but take publicity campaigns against employers to try and get them to kind of throw their hands up and say, okay, we'll agree to a neutrality agreement with you or a card check agreement with you. Reverse the position on presumptively valid employee handbook rules. And this is where it applies to a lot of non-union employers. If you have handbook rules, what the unions are going to do is take your handbook and go through it and say, hey, this looks like it is impeding or would chill union activity. This policy here that says you can't share information with other employees. You can't post something on social media. You have to act respectfully to your coworkers. And they look at those now and say, well, no, what this is telling people is you can't talk about the union. You being respectful how do you respectfully demand your employer give you a raise or do other things? So they're going to say that those are unlawful. Your handbook policies are unlawful. It's an unfair labor practice to have a confidentiality agreement that prevents them from talking about it. It's unlawful in your handbook to have you can't use our company logo without our permission, because you have to let them put your logo up on a picket sign with a circle and a line through it when they're saying, shame on this company for not paying us right. So they're going to look at those and say, that's unlawful. You'll get an unfair labor practice charge, and then the union can rally around that as well. Look at what the company's doing. Under the Trump administration, they took an approach where they said, let's look at these. If a normal person would look at it and say, this is something that's going to affect unionization, it's going to be okay. Certain things were clearly not, but now they removed all of that, and some of those rules that were in place prior are back again, giving unions that area to go into. They changed other rules, allow unions to hide certain dues information from workers, allowing unions to limit the time frame for workers to rescind their dues authorization. Allowing, under the Trump administration, the labor board said, you have to give your workers information when they ask for it about the time period for revoking their dues authorization checkoff, not just put it somewhere on your website that they can't get to, maybe under just make it hard for them to actually exercise their rights. But now they're allowed to hide that again. More anticipated changes. So President Biden's platform again specifically indicated that he would seek to reinstate specialty health care, which is a ruling that was overruled in 2017. And really this allows unions to form micro units. So if it thinks it has the support of, let's say, your second shift machine operators, but not your first shift machine operators, let's say we file a petition just for the second shift machine operators. Make it easier for them to pick up a small group, get their foot in the door, where typically to have an appropriate unit, you'd have to take everybody first, second, third shift that was running those machines, subject to the same terms and conditions of employment, working for the same supervisors, and there would be a fight over what was an appropriate unit. Now it kind of goes back to specialty healthcare, which says appropriate unit is whatever the union wants a petition for, if that little unit itself doesn't have people that shouldn't be in there. So it makes it really easy and encourages unions to try and come in and organize small units to try to get their foot in the door. The Biden board also likely can target the Boeing company decision, which overturned a decision that held neutral rules are unlawful. This is the Boeing company decision is the decision that laid out some criteria that said, we're not going to look at handbook policies if to read them, we're going to bend over backwards to try and find some bad meaning to this if it's not there, and set out some rules. That has been, or that likely will be overturned as well. Okay, so we'll get back to talking about some union stuff, but first, we'll also talk about U.S. Department of Labor, a joint employer rule, and independent contractor rules. So these are things that are kind of talked about over the last several years, kind of hot button issues, whether or not somebody's considered an independent contractor, whether or not two separate employers should be considered joint employers of a specific employee. And so under the previous administration, they had issued rules from the U.S. Department of Labor on joint employer and independent contractors, really making it easier for someone to be considered a independent contractor and making it more difficult for two employers to be considered joint employers. On March 11th, pretty soon after President Biden took office, the Department of Labor issued notices of proposed rulemaking to withdraw those two rules that were put in place under the Trump administration DOL. And then on May 5th, the DOL actually withdrew the Trump's administration's independent contractor rule. Businesses sued to reverse. That's still pending. So under the independent contractor rule, what was changed under the Trump administration is the Department of Labor actually defined independent contractor under the Fair Labor Standards Act. And the Fair Labor Standards Act is kind of wage and hour, paying overtime. So you don't have to pay your independent contractors time and a half. And so there's never been a definition by the Department of Labor. There have been cases that have come out that talk about, you look at the economic reality test, is this person really an employee or not? Do you control what they do from day to day? Can you control the manner and means of what they're doing? The Trump administration kind of relaxed some of that and made it easier for people to be considered independent contractors. And really, the withdrawn rule, individuals will be considered employees if they're economically dependent on the employer, and independent contractors if they're in business for themselves, not economically dependent. And also really that rule, which we don't go into deeply here, focused on control. The more actual control the employer or the purported employer had over the purported independent contractor, the more likely you were to be the employer. And so even under the economic realities test, they don't focus so much on control. So even if you have reserve control, say you have a contract with an independent contractor and you have the right to inspect something, the right to have him fill out reports or certain things like that, the right to tell him when his hours are, but you never do it. You never exercise that control. Under the Trump rule, you had to exercise actual control over that person, not just have some reserve rights clause in your contract for them to be considered an employee. But that rule is now withdrawn, and we are then reverting back to the Obama rule. And really, this is just the old economic realities test. It's something employees have grappled with for a long time, and it really just talks about the economic dependency of the employee. So if you're an independent contractor, you work only for one purported employer. If you're only working for one, you're more likely to be considered economically dependent on that company, and therefore more likely to be considered their employee as opposed to an independent contractor. And the economic realities test kind of minimizes the element of control. So even if the employer doesn't have much control, if the purported independent contractor is economically dependent, it's more likely they might be considered your employee. So what's going to happen now? I mean, we're under the old rule, but President Biden has indicated that he is a fan of the ABC rule, which is California's rule. And I don't know if you guys have heard about AB5 in California. That's the kind of where they want to try and do away with the gig economy, Uber drivers, Lyft drivers, other freelancers that are independent contractors. And in California, these governments want to get the tax money. So someone's an independent contractor, there's no withholdings taken out of their paycheck. And as self-employed, they may have some write-offs and other things, business expenses that minimize the tax that they're paying. They would like to have all that just coming out continuously being paid as payroll withholding taxes. So in California, the ABC test is in place under AB5, and you have to show three things to be considered a true independent contractor. One, that the worker is free from the control and direction of the hiring entity in connection with the performance of the work. The worker performs tasks that are outside the usual course of the hiring entity's business, and the worker customarily is engaged in independently established trade. So a lot of truck drivers, owner-operators, things like that have traditionally been considered independent contractors are really hurting in California, or the trucking firms that were employing independent contractors are finding out that a lot of times these guys are going to be considered their employees, regardless if they own their own truck, regardless if they lease a truck from you, because you're telling them kind of when to take this load, when to do other things, the manner in which they're doing it. You may have them fill out reports, bills of lading, and other things that they have to turn in and under how you would like them to do it. And if you're a trucking firm, these drivers are not doing anything that's outside the normal course of your business. So if any one of these things fails, the individual's an employee. You need to meet all three of these three things for the employee to be considered an independent contractor. And we'll see if the US DOL moves in this direction or not. Okay, so joint employer, kind of the brother of independent contractor. And again, Trump administration put a rule in to make it more difficult for two employing entities or purported employing entities to be considered joint employers. And why is that important? Well, if someone is a joint employer of two separate employers, he has two employers. He has two places to sue, two places that if he's not paid his wages, he can go to either one of them to try and enforce that. Two places that may be on the hook for workers' comp if they're injured. Two places for any number of those things. So the Trump rule basically said that we're going to look at 4 factors. Does the purported joint employer hire and fire the employee? Does it supervise and control the employee's work schedule or conditions of employment to a substantial degree? Does it determine the employee's rate and method of payment? And does it maintain the employee's employment records? And so in many instances where you have temp labor, currently you're probably a joint employer of that temp labor, specifically if you don't have an on-site supervisor from the temp agency that's directing the work. If you have your own supervisor directing the work, you're probably right now considered a joint employer. The Trump rule was probably made it easier for that situation even to be considered a non-joint employer. And other things, for joint employers, it's easier than for a union to organize both of you at the same time. You're on the hook for unfair labor practices that might be committed by the other joint employer. So the final rule has been rescinded, and we revert back to the existing prior rule under President Obama, where it kind of breaks down 2 different types of joint employment. Vertical joint employment, which is where typically you're using a staffing agency, and then horizontal joint employment, whereas you have an employee who might be working separately for 2 different companies. And if those 2 companies are connected enough, we're going to consider them joint employers. And where that comes into play is the Fair Labor Standards Act, because you add those hours together to determine if that person worked 40 hours a week or not, and now you've got both employers on the hook for paying overtime there. So there is a lot to be concerned with there, as we're kind of going back to making it easier for employers to be on the hook for all those things. Will the DOL issue a new joint employer rule? We're not sure, but there's pressure for him to do so to make it even more likely that employers are considered joint employers. The NLRB has vacillated back and forth depending on who is in control to determine whether or not joint employers are going to be found, and especially that who has control or whether there's reserve control. Now we will be back to, if there's reserve control, even if you're not exercising that control, you're going to be considered a joint employer, where before or under the Trump administration or under Republican labor board, they would make it harder for 2 companies to be joint employers. So you would have to actually exercise that control over the employees. So you got to look at the extent of direction and control to make sure that if you're exhibiting it, you are probably going to be a joint employer. Yep. If the 2 companies that the employee works for are completely different, no same people owning it, no supervisors that are working for the same companies. So if they work for the day at, ABC Factory, and they work at night at McDonald's, not joint employers. If the franchisee who owns the McDonald's also owns the ABC Factory and frequently is having people go back and forth, uses the same supervisors or managers, maybe it's on the same site or something, now it's going to be harder to say, oh no, the 38 hours he worked over here shouldn't be counted on top of the 15 here. Those are separate. So the more related the 2 companies are, that's where you're going to be. And they're making it easier to find 2 companies related. But and that's the horizontal joint employer. Typically where it comes into play is the vertical. But there's many instances where, let's say, somebody owns 2 different sister companies or things like that. Yeah, so you wouldn't have that issue. Okay, so we're going to end with the other scary stuff about unions. And so there is what's called the PRO Act, Protecting the Right to Organize Act, that has passed the House. It won't likely pass the Senate. It's been pending for a while, but it's not going to come to a vote at the Senate. But this is really the 50-year wish list of every union organizer, and everything that the law right now says they can't do, or every rule that they have to play by, can be thrown out the window. And everything that an employer fears as far as having to bend to a union, or having to put up with picketing, or being found to have committed unfair labor practice, or what are the fines and penalties for unfair labor practices, those all would increase and really be impactful. So, what's in it? And again, I just want to emphasize, this is like everything they've ever wanted forever. It's about the best way I can describe it. Would remove most restrictions on union strikes and other union pressure tactics. Would start to take away employers' ability to even contest. And right now you have, as an employer, you have your rights under Section 8C of the Act to give your opinion and give your information to the employees and say, we don't think it's a good idea. We think you should vote no if there's a union election. It really makes it harder for employers to exercise their free speech rights. It's unlikely, again, that it'll pass just because of the makeup of the Senate. But as a lot of these things are coming about, the budget reconciliation bill, I guarantee, has several of these things in there. When they were passing the COVID relief bills, initially they were putting in, if you want to take this loan, then you've got to agree to stay neutral in any union organizing attempt at your company. These are things that were in the bills initially. So they're kind of always trying to cram these things in there, and then they can say, how dare you withhold money from these people on COVID relief? But really, I mean, there's so much stuff that's in these bills that have nothing to do with it. And same with the infrastructure bill and other things. So they're trying to sneak in this stuff in any of these big ticket items that people just can't read every line item of. I mean, the legislators don't even read this stuff. You can't really expect everybody, the lay people, to do it as well. So, what are some things that are in there? So, and this is just, the next few slides are just part of what's in here. So, changes to organizing and union elections, the PRO Act, and I haven't scanned to see if anybody has any questions. I'm doing such a great job, there's no questions. It's crystal clear. It expands which workers unions can organize. So right now, supervisors are not considered employees under the National Labor Relations Act. They can't be in a unit with non-supervisory employees. And a lot of times in union elections, those individuals, there's fights over who's a supervisor, who's not a supervisor. They want to remove that and make it easier for people who are currently considered supervisors to be organized, and independent contractors. Make it easier for someone who's an independent contractor to be considered someone who ought to be included in your bargaining unit. It erodes the secrecy of the secret ballot election. This is something that the unions have been trying to push for forever and ever and ever. There was something called the Employee Free Choice Act, of all things, back in, I want to say 2008 or 9 or something, and basically made card check the method instead of a secret ballot election. It means that the union can come in your parking lot or at the tavern and buy people stuff and pressure somebody to sign a card in front of their coworkers. Are you going to sign this? You're going to sign it just to get rid of them. And if they get 50% plus one, they bring it they're in. Instead of going to a secret ballot election where there's a board agent handling it, there's no electioneering going on in the election site, and it's done under at least some semblance of a secret ballot election. This would erode it. It doesn't go as far as the Employee Free Choice Act did, but basically it says if the union alleges that you committed some sort of unfair labor practice during the course of an election campaign, and the union loses, then they say, you know what, that was, instead of saying, we'll throw it out, right now they throw out the election and redo it. The employer, has to put up a posting, we did bad, we won't do it again, and we're gonna do a revote. Now they would throw it out and say, now you can do card check. Maybe, I don't know. I can't even hear what I say. Yeah. Maybe I said that. That's what the posting says. No. Other things. Allows, we talked about that. Oh, allows the union to decide the manner of the election. So forever and ever, the board's policy is we're doing a live manual election. I mean, people come in, go into a voting booth, mark their thing, put it in the ballot box. Now, if the union wants to do a mail ballot election, if they ask for it, they get it. That's what this would do. If they want to do online, if that becomes a thing, if that's what they ask for, that's what they get. And mail ballot elections are, which is what we were doing during COVID, they're so difficult to figure out who's doing what and having parties to get together to bring the mailings and do it all together. So it just makes it really, really difficult and a lot easier for unions to pressure employees to fill out a ballot in the presence of other people. Okay, what else we got? Collective bargaining. So once a union's in, changes rules. Right to work states. A lot of people don't understand what right to work states are. They think it means at will, and it's not. What a right to work state is a state that has outlawed what's called the union security provision. And that provision is a provision in a collective bargaining agreement that says, hey, anybody in the collective bargaining unit has to pay dues. If they don't pay dues, they get fired. That's a union security provision, and that is outlawed in right to work states, and there's 26 or 8 right to work states. Illinois is not. You would still be able to object the same way you do now. And that, the question was, is there any impact to Beck objectors? And those are people who say, I don't want to be a member of the union, even though there's a union security clause here. I don't want to have to pay union dues to work here. And you have some right to do that, but the union just charges you what's called the agency fee. It's some smaller portion of the dues that only go directly to collective bargaining and any of the other stuff that the union uses your money for. So you'd still have that, and I think they'd have a hard time getting out of that, especially with like the Janus decision for public sector employees kind of going that way with this in the Supreme Court, but it would ban right to work states. So every state would have to allow union security provisions. So force unionizations, pay dues, or pay agency fees if you're an objector, or lose your job. It provides for interest arbitration. So right now, the way the law works is if a union comes in, what they get is they get the right to sit at the table and ask and make proposals. And the company's got the right to make its proposals. And there's no requirement that an agreement is ever reached. There's no requirement that the company agree with anything the union proposes. There's no requirement that the union agrees to anything the company proposes. Nobody has to make a concession to the other. You just have to bargain in good faith. You can't surface bargain, you can't act like you're bargaining, but you're not really bargaining. You can't decline to sit at the table. You got to meet regularly, consider their proposals, make your proposals. But under interest arbitration, which I know Julie's got some experience with probably in the public sector, this is how public sector bargaining is. If you don't reach an agreement within 30 days or 90 days, you go to an arbitrator and you present your case to the arbitrator about wages, and the union presents its case to the arbitrator about wages, about time off, about other working conditions and benefits and pension contributions, and the arbitrator decides what your wages are going to be for your employees and what your pension contributions are going to be and everything else that you can't agree to. Allows hot cargo agreements, which are currently banned, which means that a union right now can't get an agreement from a company that says, hey, we don't like Julie's company. She's non-union. But they're going to come to me because they know I do business with her and say, listen, let's have an agreement. You don't deal with her. If you do, we may find yourself picketed or some other things. And so we agree, okay, we won't do work with Julie. That's unlawful. Unions can't do that. Companies can't agree with unions to hot cargo agreements. This would do away with it. It would outlaw that. It would give the unions that quiver or that arrow in their quiver. It bans employers' ability to withdraw recognition from a union. Even if all your employees sign a petition and say, we want the union to go, we don't like them anymore. Even if they all stand in front of you and sign it, you know it's them. you can't withdraw recognition from the union. Right now, you can in certain circumstances. There's certain small windows you're allowed to do that in when there's no collective bargaining agreement in place, or a really small window between the 60th day and the 90th day before an expiration of a collective bargaining agreement. But this would say you can never withdraw recognition as an employer. The only way employees would have to file their own petition and go for a vote, even if they all come to you and say we don't want them anymore. Right now you're allowed to do that in those limited circumstances. Strikes, picketing, and construction site stuff, this is this is where it gives it takes away any rules that the unions currently would have to play by when they're picketing. And you've all seen the rat, that's out there. It's ubiquitous now, so nobody really cares about it, I don't think. Except for it's a signal to union workers who might be working at that construction site that says, hey, don't work. You're not working today. So secondary strikes and secondary boycotts are strikes against, again, go on strike against Julie because they have a problem with me. Maybe she's a general contractor. Maybe she owns the property where I'm doing some work for her. They can go and picket against her. They can't do that right now. They can put up the rat against her. They can exercise their free speech rights. This would allow them to go and march with picket signs, across her own property company, not even where the job site is, would allow them to engage in that secondary strikes and boycotts, which currently are unlawful. And it would give them the right basically to shut down construction sites. They could picket against anybody at the construction site, and those people wouldn't work, especially if they're union workers. Right now, you set up 2 gates. They have to picket at the one gate where they have a beef with the one contractor. Everybody else comes through the other gate that's not picketed, and it's not lawful work stoppage if they don't, if they stop working. That would change all of that. Allows partial strikes, intermittent strikes, slowdown strikes. These things are all unlawful right now. Unions are not allowed to strike on Monday, come back to work Tuesday, strike on Wednesday, go to back Thursday, strike on Friday and Monday because they want a long weekend. They can't do that. You're either on strike or you're not. And so intermittent strikes are unlawful. You can get an injunction against them. This would allow it. It would allow partial strikes. So right now, if a union calls a strike, it's called a strike. Everybody in the bargaining unit is on strike. This would allow, we'll take these 5 people out this day and these 5 people out that day and everything else. And slowdown strikes. This will be allowed to just, take breaks and say, I'm on break. I'm on strike right now. I'm on strike for these 5 minutes, so I'm not going to do my production for these 5 minutes. Now I'm back. Would allow all of that to happen. Allow strikes in jurisdictional disputes. This is where unions are fighting over each other. That's our work. No, it's our work. Right now, they're not allowed to strike in support of a jurisdictional dispute between 2 unions. Now you would be able to. So an employer has a union contract with one union. Another union comes in and says, that's ours, and they picket, and they go on strike, and it causes everybody else on the job site to leave. It's going to be allowed if this passes. Removes all time limits on picketing for recognition. So you can only picket for 30 days for recognition. If you can picket forever for area standards. Hey, we don't think you're paying these people enough. If you are saying you ought to recognize us as the bargaining representative of your employees, you can only do that for 30 days without filing an actual petition to get an election. That would remove that. They could picket forever for recognition. Bans employers' ability to lock out employees. So union gets to go on strike. They have that economic weapon, but it would remove the employer's ability to institute a lawful lockout, which you can do now. Not many employers do it, but it happens, and it's effective when they do happen, but this would outlaw that. And then damages and fines. So civil fines of up to $50,000 for any unfair labor practice and doubled for repeat offenders. Right now, there's no fine for an unfair labor practice. Certain things are, the only thing that the labor board can do is have you put up a notice posting. Employees have the right to do X, Y, and Z. We won't do this bad thing that we did anymore. You leave it up for 60 days, and that's it. Now, they can award back pay to somebody who's been terminated as an unfair labor practice because they support the union who fired them. That's unlawful. If you have to hire them back, you got to pay them back pay. This adds more. Requires employers to rehire employees pending resolution if they allege that you terminated them for their union support. So right now, just an allegation. So right now there's something called 10J, which is an injunction that the labor board can get to say, no, you've got to go back. Hey, employer, you did this thing. Famously, Boeing shut a plant in Oregon and opened it in South Carolina, and they said, yeah, you closed that plant out of retaliation for other union activity, so you got to open it back up. That's an injunction that said you have to affirmatively do that. Right now, a union could petition for an injunction if you fire someone or something else. Hey, you changed these rules. That's an unfair. You didn't bargain with us. You changed these rules. The labor board can say you got to change it back until we get this figured out. You got to keep the status quo. Typically, you only get an injunction if you can't get the remedy at the end. If to not give it back right now would just ruin the purpose of the union's claim. Firing somebody typically is not, because they get back pay, so they get a make whole remedy. They get back pay. They get their taxes grossed up. They get their benefits back. They get made whole, even though they've maybe been out of work for 6 weeks, fired, and then if the labor board finds that it was unlawful firing, they come back with back pay. Now they say, yeah, we don't care. If we allege it's an unfair labor practice, you got to bring them back to work until it's determined that it wasn't an unfair labor practice. In discharge cases, in addition to back pay, it would allow for front pay. So let's say the guy doesn't, not coming back, you got to pay front pay. Liquidated damages, 2 times the amount of back pay. This is like the Fair Labor Standards Act. So we fired you for a week. Now we got to pay you 2 weeks and bring you back. And then consequential and punitive damages. Consequential damages is already something that Jennifer Abruzzo, the new GC of the Labor Board, has put in another GC memo that she's pushing for, even in current cases. So not only back pay, but any consequential, they'll say something happened because the employee didn't have health care while they were terminated. You don't just have to pay them for their benefits, the amounts you would pay for their benefits and their wages. You've got to pay for any consequential damages that flow from that. $10,000 daily fine for noncompliance with an order. So if the NLRB says you got to reinstate this person and you don't do it, $10,000 a day until you do. Personal liability for company directors and officers. We got anybody in there? Okay. And provides employees with the right to sue employers in court even if the NLRB dismisses their charge. So this is like EEOC. You don't get a right to sue letter. You file an unfair labor practice charge, the labor board says, yeah, we don't think there's anything there. Okay, I'll go sue you in court. And now you're, if they want to get their pound of flesh, there's ways to get it, enforcing you through litigation. Even if it ultimately goes nowhere, they know that you're likely to, settle with them, because it might cost less to do that than to fight it in court. Okay, who are those people? God. You talking about me? Hair. Hair. Yeah, okay. Any questions? I know we kind of sped through that. I wasn't sure of my time, but certainly. I mean, you've seen with the fight for 15. So the UFCW and the service employee and SEIU are really trying to drum up organizing low-wage workers. In food service, there's always been a lot of representation in the hotel industry, but kind of across, where you have a lot of times transient workforces, right? You got a lot of kind of people who come and go from McDonald's, and traditionally don't see the benefit. I'm just getting some extra money here. I don't want to get involved in all this stuff. I don't want to have to pay dues. You're getting more and more organizing there. The cannabis dispensaries is a big push right now. I've got 2 of those going on right now, and each with 2 unions fighting over their right. So the UFCW files a petition to come in, and the Teamsters say, no, we want it too. So we have three selections on the ballot, and I imagine they're going to be going into like the cultivating. These are store dispensaries, but the cultivating areas are probably going to be organized as well. And now we'll see how private university student athletes go. We'll see how that comes along. I can expect we'll see a petition filed pretty soon on that. Well, right. I mean, it's all going to be negotiated, and paying taxes on their dues, even though they never see them. So that's pre-tax, or that's, you never see in your paycheck, but you pay dues as income on it. Definitely landscape industry. I know Julie's got a number of landscape clients, but absolutely in the landscape industry. We don't have, up here, we don't have so much agriculture. What's that? Snow removal, right? And so you have a lot of these equipment operators or excavating companies that have their guys, gals doing snow removal in the wintertime. Those are now getting to be a hot topic.
The larger landscapers that are doing the removal, the hardscape and for more like commercial properties, yeah. For the more residential, smaller ones, not as much, and it's perfect because of the transient nature.
And you've got a lot of fights, jurisdictional fights going on between laborers and equipment operators over who is going to represent those smaller, bobcat operators at places. So there's plenty of activity there. So sorry I wasn't repeating the questions like I was supposed to, but this is, am I seeing a shift in generational, I guess, organizing? It's interesting because at these two, the cannabis, there's a lot of young people working there. They're trying to get a handle on what the issues are and how to put a campaign on is difficult. You've got a lot of people that are, even the managers, and trying to, get them to, flesh out and give the message to the employees. I think there's a reluctance to, there's a lot of, I know there's a lot of, amongst that demographic, the young person who works at a cannabis dispensary, they are predisposed probably to be, hey, we think unions are a good thing. Until we'll see how these things go, but until they're getting the messaging, especially when they're only getting the messaging at the front side from the union, and a lot of them think if the union wins the election, basically that means there's a contract on a shelf that we are now subject to, and it's not the case. So there's not a lot of education of what it means. They don't have a lot of baseline, right? There's not a lot of baseline knowledge of any of that. Right. So, and it makes it difficult because you have to walk a fine line in how you run your campaign because you can't take a super aggressive tone. You have to take an educational tone. But yeah, I haven't had one where we've got a big kind of breakout between older workers and younger workers, and a lot of times there's a lot of factions that are going on during an organizing drive. You got kind of the old people who have worked at it. You don't see people working for 40 years or 30 years at one employer anymore, and those people are a lot of times.
You don't see people working for 3 years.
Right, and so which typically you would say would cut against union or organizing because you got transient nature. People are, I don't want to be in this job for that long. I don't really care. I just I'm going to be here and get what I can and then move on somewhere else. But you've got the older people who want to be there, and so they can go either way based on how they feel about the employer. But it's hard to read the newer people, recent college grads or recent high school grads entering the workforce right now. They're kind of a tough nut to crack as far as where they lie on a lot of this stuff. So the question is, if they're seasonal employees in like landscaping or snow removal, are they still part of the union, or does the union control them during the off season? Yes and no. The union doesn't. A lot of times, if they're considered a construction company, and a lot of landscaping companies can be considered construction companies. In that case, just because typically if a job ends and you lay people off, and then you might go to another job and you're not hiring everybody back, typically under the labor board rules, you'd lose the bargaining unit. They'd have to reorganize these new people over here at this next job. In the construction industry, because of that, they're allowed to get an agreement with they're allowed to come directly to the employer, a union is, and say, sign this. It takes effect immediately. There's no election. You can just agree, what's called a pre-hire agreement, agree with the union that you're going to represent our employees. And we have these area-wide agreements that that apply to all the landscapers that sign. So it's one contract that covers maybe 4 counties or something like that. In that case, they may have to pay dues, even though they're not working under their rules of the union. So and then they have to pay maybe an additional amount when they are working, called working dues. So they may have obligations to the union in certain circumstances, even though they're not working at the time. But if they want to keep their card, if they want to stay on the recall list or rehire list, they've got to stay up with their dues. No, in those situations, no, there's no payroll to take it out of. In those situations, usually there wouldn't be dues check off for that. Maybe for the working dues, but not for the.
Well, thank you guys. We appreciate it. Thanks for coming out.
Thanks, everybody.